Good afternoon. I'm so excited for today's class. As most of you probably know, my name is Anthony DiUlio. I am the owner and partner at Wheeler, DiUlio and Barnaby, where we focus our entire practice on property damage litigation. That includes first-party insurance claims, negligence claims against contractors, error and omission claims against agents. We generally tell people if something went wrong at your property, we can probably help. Today we are broadcasting from home. I stayed out of the office today. I had a stomach bug yesterday. Decided it would be best to try and make sure nobody got sick. So feeling better today, but wanted to play it safe. We've got a few minutes as some more people are signing on before we get rolling on this. But I wanted to start off with a very special thank you to everybody who was involved in the PAGPS conference, specifically Holly Soffer, who was integral in putting it together along with all of our sponsors. It was an absolutely amazing turnout. We had 125 people who registered and showed for the conference, got through some amazing courses. We're sending out emails to get all the reviews back, but we're hearing absolutely fantastic things. Hopefully you will be able to join next year. So today we are going to be talking about appraisals. It is one of the hottest topics in the industry, and absolutely something that needs some attention, to say the least, from everybody involved. Appraisals have become far, far more prevalent, and as they've become more prevalent, they are becoming more and more contested and complicated as a result, because in the end, the carriers don't want to be paying any additional money on claims. So they are throwing up as many hurdles as they possibly can through this process. So we want to address how to deal with those hurdles, how the appraisal process should actually run, and what to do when it doesn't go as smoothly as you hoped. So for today, we are going to go through a number of things, but at the start of all of these, I want to make sure I give everyone access to me personally. On the slide here is my personal cell phone number. That rings right here. You are free to call me, text me, whatever you need to do to get in touch. And I tell everybody, I'm in depths a lot. I'm in meetings or trials. I'm indisposed for one reason or another. So don't feel bad bugging me. I don't mind if you follow up. If you've texted me in the morning and follow up in the afternoon, it's not a bother to me at all. Please follow up, because a lot of times, candidly, I just need it as a reminder. It also, on this slide, is my email address. Again, that is my personal email, direct to me at the office. You can reach me anytime on there. And I'll be happy to discuss any questions, concerns, problems you have with cases, policies, whatever I can do to help. I tell people this almost every time I talk. I don't want you to have to send a claim to me. One of the reasons I do these classes isn't so that you end up having to send me something. It's so that you can avoid sending it to litigation. We are in an industry where we are against the big bad insurance companies, these monolith companies with endless amounts of resources, who are constantly going to push for things like legislation and practices that lower the amount of money that they owe on claims. We have to work together as an industry to put the best foot forward, to be the reasonable side, to be the side that is not looking to pull one over, to be greedy, but to get property owners back to where they were supposed to be and to get what they are owed under their policy. If we do that together, we can make this industry better as a whole. So with these claims, there are a number of things that happen throughout, and we've been doing this entire Perfect Claims series, really talking about formation of your company all the way through the resolution of the claim. And we're rounding out to the end. We're getting towards all of those resolution points, but if you haven't gone back and watched those prior classes, I highly recommend that you do that. Today, we're going to be talking about appraisals. We're going to talk about a lot of aspects of those appraisals when it comes to your process and what you should be doing, and hopefully you will gain something from that. Before we dive in, I say this at the beginning of every single one of these perfect claim series. Not every claim will be perfect. There are variables, there are issues that come up. Just because a claim is not perfect does not mean it is not covered, doesn't mean that the policy payments shouldn't be made. There's a ton of different variables. So just because something doesn't go just the way I have discussed doesn't really mean much, other than you might have made it a little more difficult for yourself throughout the claim, but it doesn't actually change coverage benefits. The policy is the controlling factor here in most cases. So if you've got policy language that leads to coverage, the rest of it really shouldn't matter all that much. We just last week, I always talk about the summaries, be very brief on this. We talked about some of the common hurdles that you will see through the adjusting process and talked about how to deal with those hurdles, dealing with certain policy language that can be problematic and consistently argued incorrectly. So there's a number of reasons that you can fight back and ways you can fight back. You should go back and check out the part 9 of the series to deal with those. Today, we're going to go through a number of aspects, but really 4 main issues. First and foremost, how to make a process for appraisals. And what I mean by that is an actual guideline that you will use through the appraisal process to make sure things move smoothly and consistently every single appraisal you have. That should be your goal, and we're going to talk about some of the specifics of that. We're going to talk about some key items that make a good appraisal, things that I keep seeing over and over again whenever an adjuster calls me or I'm litigating over an appraisal. These are the things that can make a difference from the good ones and the bad ones. Now, just like in every scenario, there will be appraisals that aren't going well. And then we want to talk briefly about how to deal with those problems when they come up. And then, of course, when the problems come up and they can't be resolved, what are your options? One of the most consistent questions I get is, hey, something went south with the appraisal. What can I do now? So we're going to talk about that as well. We have a number of questions that came in beforehand, but I want to remind everybody that is on here, if you have any questions, just type it into the chat. It pops up on this nice little screen to my side. I can read them here and actually post them right up to the page for us to discuss live. Use this as an opportunity to further, dive in. If you want to know more about something I talk about, if there's a question that has been, bugging you, throw it into the chat. Happy to discuss those. One of the reasons I do this is so that you can have that kind of live access to answers whenever you need it. So let's talk about the appraisal language that exists in a number of policies. Now, as I've said, the policy language controls. I've said this a number of times in different classes. And if you don't know it yet, you should know it. Read the effing policy, right? RTFP. Now, the F can stand for a lot of fun things, but the truth is it can stand for full, and it's probably what it should stand for. Read the full policy. Whatever it says in the policy will be your guiding factors. There are some rare circumstances where policy language can't be enforced, but that is extremely rare, so you should be going in and reading. I wanted to give an example of an appraisal provision that is relatively standard using ISO language. But again, this is by no means going to be consistent across all policies. For example, State Farm and Farmers have significantly longer appraisal provisions. So you're going to want to make sure you read those to understand what those policies say. However, we've got some example here. This is actually from an Allstate policy as to what's in the appraisal provision. And there's some key aspects to this provision that I want to talk about. So first and foremost, one of the biggest disputes that is going to come up in your appraisals is what can be appraised. And really where that falls is dependent on what state you are in. Every state has different case law on the issue as to what can be appraised. Now, from my perspective, it shouldn't really come down to case law because the policies in my eyes are crystal clear. If you and we fail to agree on the amount of loss, period, end of story, amount of loss, then it's ripe for appraisal. So if you want to replace a roof and they want to patch a roof, that is an appraisable issue. However, the truth of the matter is there are some states that have come back and said, no, the only thing that can be appraised are those items that are specific to the carrier's estimate, things that they have already provided coverage for, and it is only those items that can be appraised. So really, we need to know the case law for whatever state we are working in. If you are not familiar with whatever state you're working in for their case law on appraisals, let me know. I will, if I don't know the answer off the top of my head, I can certainly find the answer for you. But the language there for amount of loss is critical because some carriers have actually been changing that language. There are some carriers who have written amount of loss, comma, not the scope, comma, either party may make a demand. They're trying to limit that appraisal only to those items that they've agreed to pay for. I think it's the wrong direction for the industry to be going in, and we're working on some issues with actual local legislators on that. But for now, we're basing it off of the policy language. And Ed, that's a great question. We are going to get to it, luckily, because you asked that question before. I have it addressed in one of the questions at the end. But next, we've got the next language of written demand. So there's two important words here. First, it has to be written. You have to make all demands for appraisal in writing. Sending a voice message to them is not going to be good enough. You need a written demand. All of your writing should have, for appraisals and really for most of your claims, should have form letters. If you don't have a form letter for an appraisal demand, you are doing yourself a disservice. In a little bit, we're going to go through just an example of how my forms work for my office, because I want you to understand how easy it is once your system is set up to do these form letters. Next is the word demand itself. Appraisal is not an option. Carriers have been trying at length. State Farm, for example, I know does this a ton, where they are trying consistently to push back on appraisal and say, oh, we're not there yet. We need more time, more information, more documents, blah, blah, blah. As soon as you get to a point where there is a dispute as to the amount of the loss, i.e., you have one number and they have another number, as soon as that happens, appraisal is ripe. That's it. That's what the policy says. And anything beyond that is incorrect on behalf of the carrier, of course, unless the policy says otherwise. So you need to recognize that and use that language in your letters to make sure that the carrier recognizes this isn't an option. Your policy says that this is a demand. And there's further language we're going to talk about, like must, of what absolutely must happen in the event that that demand comes through. Which gets us to the next one. Upon such a demand, each party must select a competent and impartial appraiser. The aspect of must is important, again, because it eliminates the option. I did forget to highlight one thing here that I thought was important and I wanted to note. Competent and impartial. There are a number of policies with different language here. Some say things like disinterested, but competent and impartial are really important. However, it doesn't always mean what you think it means. Just because somebody has done 40 or 50, 150 appraisals for a carrier does not mean that they are partial to the carrier. I get in daily conversation that's enough for us to say, of course they are partial, but the truth is it's not enough in the eyes of the court to likely lead to a level of impartiality. Impartiality would be, for example, being on the payroll for the company, naming an employee of State Farm or Allstate or Farmers to act as the appraiser for a State Farm or Allstate or Farmers loss. That would be something that would create impartiality. Competency is also important. They need to be competent to do this. So they can't just name, some Joe Schmo off of the street, or even candidly some attorneys that they think might be competent, because they might not have the tools necessary to properly appraise the loss. We're going to talk about some of those issues with these claims when there is a demand and you've got concerns about who they've named and how to deal with that as well. The other aspects that you get from this come to important timelines that are put into place as a result of the appraisal provision. The first one is noted here that you've got 20 days after the demand to name your appraisers. That is a very important deadline because it applies not only to you, it applies to the carrier as well. There are complaints that come in constantly regarding the timelines and the delays that occur by carriers, and you can use this language against them to make sure that they are moving it along appropriately. I did note in the next line where they talk about competent and impartial umpires for the same reason as we've talked about above. That competency and impartiality is just as important for the umpires as well. And then there's another timeline that says if the appraisers are unable to agree upon an umpire within 15 days, you or we can ask a judge, in essence, to name one for us. Within 15 days, the appraisers, and it's 15 days, by the way, of the naming of the appraiser. The 15 days of naming an appraiser, if an umpire cannot be agreed upon, they can go to the courts. But what's important here is some of this language. Yes, you've got 15 days to come to an agreement. The problem is the language after that is with a can, right? It's not a requirement. It's what's an option in the event that you can't agree. Either party can go to the court. And note that it's either you or we. You don't have to agree to go to the courts to do it, but either party can say, it's been 15 days. You have not given me a response. On day 16, you can have a motion ready to go with the courts to file accordingly. Now, if you want to do that, hopefully you've been working closely with an attorney, because most of us aren't going to turn around a motion in a single day. But if you were to reach out to us ahead of time and say, hey, look, I know that they're not going to agree. I'm willing to bet on that, and I'll retain you to do the motion, then absolutely that is one of your viable options to push this forward. Ed has a good question here that I will pop up. If a demand for appraisal is sent to the insurance carrier and includes a pre-appraisal memorandum requiring both parties' appraisers to provide a fully transparent response to a disclosure questionnaire. Now, I think what he's getting at, and correct me if I'm wrong, Ed, is, hey, I'm sending you a demand for appraisal, but I need you to send me a list of or whoever you're going to appraise or be your appraiser. I want you to answer these questions. How many times have they worked for you? What is the compensation agreement with the party? What are these other aspects of their involvement, their knowledge? Have they ever worked with Xactimate? Are they an engineer? Do they have any construction experience? That aspect of these claims. And I believe what Ed is asking is, hey, what happens if you send that to the carrier? First and foremost, I think it's a great thing to send to the carriers on every single claim. You should have a form questionnaire that you're using whenever they are naming their appraiser, so that they can provide some basis of their competency and their impartiality. However, it might not be the answer you want to hear, but they are not required to answer that questionnaire. Unfortunately, there is nothing within the contract, within the policy, that forces them to have to provide that. Unless there is an actual contest in the courts as to their impartiality, then they would ultimately have to respond with that. It is a tactic that is used on their half to delay these processes and say, look, I don't have to answer it. You can file with the courts to have them removed. But in the event that you don't do that, so sorry, I don't have to respond. Nevertheless, it should be provided, and you should ask for it, because it shows a number of things. It shows that you are attempting to keep this above the board and on the books as best you can. It shows your intent and desire to make sure you keep this with competent and impartial people. And it will ultimately show, in my opinion, some of their unreasonableness in refusing to provide it. There is always a question of how extensive your questions are. If you're getting into 20 questions about these things, about any given appraiser, you're probably going to have a hard time convincing them that it would be reasonable to respond to that every time. But if you've got 3, 4, 5 questions, I think you've got a much better shot at getting them to answer. So the appraisal provision keeps going on, and the aspects of appraisal keep getting defined further within the policy. So we have the next paragraph of the appraisal provision that also has some important language. The appraisers shall then determine the amount of loss. Now, this is important because it is up to the appraisers to determine the amount of loss. I've used this language in the past, and while there's no slam dunk on any of these, it's certainly helpful that you use this when the appraiser for the carrier is trying to use the carrier's own estimate for the amount of the loss. It is not for the appraiser to just copy and paste the carrier's estimate, or not even make their own and use that estimate. They have to independently do that. They are the ones that shall determine the amount of the loss. Now, the truth is they can go through Xactimate and recreate the estimate nearly identical to theirs, but it's not good enough to just use their own estimate from the carrier and say, I'm just agreeing with this, and if not, we're just going to go to umpire. Obviously, that is a waste of time if they do that, but we've all seen it happen. It also goes further, and it talks about how you must separate ACV from the amount of the loss for each of the items that's being appraised, which means if you're in an appraisal situation, you're going to have to actually address ACV. I know most adjusters in the normal adjusting of the loss will not put an ACV number on there. It's a conversation for a different day, whether or not it should be or shouldn't be. But the truth is that if you have an appraisal, it's actually required by the policy that the actual cash value be placed in there. The policy provisions go on. If the appraisers submit a written report of an agreement to you and to us, the amount agreed upon shall be the amount of loss. It is a binding number that is determined through the appraisal process. It's one of the most important aspects of appraisal, for good or for worse, as to these claims, because it forces the carrier into a position where it determines that it is the binding required amount for the claim. But similarly, it can work against you. And it can be a scenario where there are numbers that you aren't in agreement with that they've put on there, and that is a binding set number. There's nothing short of misconduct or fraud that is going to allow for that number to be changed. If they cannot agree, they will submit their differences to an umpire. Now, this one's important because what often comes up, and it's one of the things that I find to be problematic from the appraisers on the homeowner side of the equation, a lot of appraisers on the homeowner side want to continue to try to appraise the loss, try to change people's minds, even if the other side has set their number in and said, look, if you don't agree to it, let's just go to an umpire. Look, there is always an admirable attempt to convince them that you're correct, to convince them to shift their numbers. But there is an end to that battle. You should not just consistently say, look, we're not ready to go to an umpire yet. It would be a waste to go to an umpire now, blah, blah, blah. The fact is, if you can't get to that agreement, it must go to the umpire. There is no other option short of pulling it from appraisal as a result of some other problem that really is out there for dealing with these appraisals. Sorry, I want to make sure I read all of the comments coming through from Ed. So Ed's got a great point here, and one that's worth showing everybody. There is a case where a Hague engineer was found to be not impartial. So to be partial to a claim because he derived 25% of his income from the insurance company. And as soon as you get to those kinds of numbers, I absolutely would agree that there is impartiality involved. This was a case down in Northern District of Texas that came through. However, there is not as much similar case law through other areas of the country. Not that it doesn't exist or they've said otherwise, just that the courts haven't gotten to those questions yet. But a good point nevertheless from Ed. So I want to talk about the appraisal process, because now we know that the policy has this controlling language. We know that there are some important aspects. And as a result of that controlling language, you should have a process in place for these claims so that every single appraisal goes the same way. Having a process for your entire adjustment of a loss will actually relieve you a ton of stress, worry, and delay in a claim that shouldn't otherwise exist. And it should no difference once it gets to appraisal. The process can be very simple and straightforward. And I want to talk about what the most important aspect of that appraisal process is. And I'm going to say it now because I want to say it later. The most important aspect is the choice of the umpire. The choice of the umpire will make worlds of the difference when it comes to dealing with the opposing appraiser, getting an appropriate result on a claim. Everything can be guided and controlled by the umpire on the loss or on the appraisal. And as such, I cannot stress how important it is to get an umpire that you are going to be comfortable with their results. And here's the question that you should ask yourself. If the opposing appraiser comes back and they say that they agree more with the opposing appraiser I'm sorry if I misspoke. If the umpire comes back and says that they agreed more with the opposing appraiser than they do with your appraiser or with you, will your response be, okay, I trust and rely on this umpire. If that's their decision, then that's their decision. Or will your response be, oh, they've got it in with whoever the opposing appraiser was, and this is a improper result? And if it's the latter of those two, if it's that you think it'll be improper if they agree with the other side, then you don't have the right appraiser or the right umpire. The right umpire will sometimes disagree with you. I'm sorry, it just happens. It's going to happen in the future, and there's nothing you can do to stop it. But when you've got the right umpire on the claim, you should be much more comfortable with the result because you at least know you got a fair shake. And that's what really matters in these, is that you get a fair shake and get to the right result in the end. And if you've got someone that can be trusted, then that should be enough to get you there. So the process you should make should always be the same in every one of them. And you should use things like workflows and forms to help push that process forward. A workflow is really any set of predetermined steps with predetermined dates that are being used on these appraisals to set, hey, I know I'm going to be doing X on day 2 and Y on day 5, and it's always going to be the same, and this workflow is going to help me walk through that. So let me give you an example of I put this together a couple hours ago as to an example of what something like a workflow might look like. So workflow, day 1, when you were assigned as the appraiser, you send an introduction letter to the opposing appraiser that outlines things like your timelines that are anticipated on the claim, your goals, a scope of the appraisal, other important information. It came up at the PAGPS conference, and I thought it was a great idea, not something that I've actually seen a ton of appraisers use, but is to have an actual appraisal agreement with the opposing appraiser set in place before you do anything else on the claim to try and set certain deadlines for yourselves. So, for example, set timelines, set expectations for the scope of the appraisal, all of that in writing before you get to the contentious point of the appraisal. Right? It's nothing out there requires that this be done. You can't force the other appraiser to sign something, just like they can't force you to sign something. But there is no harm in asking. And in the event that you get a scenario where they do sign it, you've got a lot more leverage if things start to go south to say, hold on a second, right here, you signed this document, this agreement that says you will do it XYZ way. We can't falter now. I thought it was a really great idea. If you're not using that, you should. And I'd be very curious to hear from the people on the Lunch and Learn Now. If you've used this, have you had some success with it? Is it something that always fails and you don't bother anymore? I'd be really curious to hear any comments on that. So day 1, you send the introduction letter. Somewhere between day 1 and day 10, you have this signed appraisal agreement with the opposing appraiser. And then from days 10 to 15, you focus on umpire selection. Umpire selection, and this is a contested issue. People feel really strongly about this on either sides of it. I don't look at whether or not there's a right answer. I don't know. I know I have my opinion. You should choose your umpire before you get into the appraisal with the other side. And the counter to that, I know the counter is, well, look, I might never need the umpire on the claim. Why am I going to spend time and effort on choosing an umpire and dealing potentially with contested issues of who we're going to pick and going to court and doing all that if we never end up needing them? The truth is, if you can't agree to an umpire before the appraisal process starts, it is probably a red flag that you're not going to be able to agree as to the aspects of the appraisal. So if it is a contested issue before the appraisal even begins, then you're probably going to be right back here anyway at the end. And now you've not only wasted time, but you've lost other resources and had other issues that have come up that will make it even more difficult. However, the alternative, if you can agree to an umpire now before things get contentious, before things, you start going toe to toe with them over the issues of the loss, and you've chosen this agreed upon umpire, now you've got a situation where it's already set as to who they are. You don't have to worry about them arguing just for the sake of arguing who the umpire is. I mean, it makes a ton of difference. Not only that, but you can use the umpire throughout the claims or the appraisal process to assist with certain things like the timeline, non-responsiveness, issues that come up through the appraisal can be resolved by the umpire. They are the tiebreaker for all of this, but in the end. So if you need them to start setting deadlines, for example, I need an estimate by X date, they're allowed to do that. And they can set that deadline. You present your claim package in time. If the other side doesn't and they don't produce it, and the umpire ends up ruling in your favor because you did give them what they want when they wanted, well, you've now had a much more successful appraisal than would otherwise have happened. So I really believe pretty strongly that you should be selecting your umpire within those first 15 days of the appraisal process, really every single time. So we've got that's days. Now we've got days 1 through 15 taken care of. The next one should have been 15 to 30, but within 15 to 30, have your joint inspection of the property. Now, a lot of you are going to tell me, well, look, this timeline is really fast, right? Trying to get all of that done within the first 30 days, your joint inspection, selection of the umpire, your appraisal agreements, is a lot to do. I got to be honest with you. If you can't do that within 30 days, you shouldn't be appraising claims. It means you've got too many claims on your plate and you shouldn't be doing it. One of the biggest problems right now with appraisal is how long they are taking. And I know it's not always your fault, and that's fine. And there will be scenarios where it's not your fault and you can't get out there. But if you are the cause of the delays, you've got to really reconsider either becoming more efficient with your own process or just taking less appraisals on, because it's doing a disservice to everybody involved if you cannot put the appropriate attention into the appraisal. Please take that to heart, because I hate seeing claims that get delayed as a result of the appraisal process for things that could have been avoided if people were just moving these efficiently through. All right, so we've got days 20 to 30 for the joint inspection. You provide a positions letter from day 30 to 35. And that positions letter shouldn't have your numbers yet. What it should do is be confirming things that you saw at the inspection, confirming conversations that you had. Just like with every aspect of the claim, documentation is critical. So you want to make sure that if you have a conversation with the opposing appraiser during that joint inspection of, hey, you agreed with me that there was, damage to the wall in the kitchen and that it's continuous through the living room and the dining room and up the stairwell. We recognize that. Just putting it in writing so that, it's memorialized and it's not just some verbal conversation. Putting it in writing makes a difference when there are problems later down the road. It also makes a difference in the actual appraisal itself, because it lets the other side know, hey, you remember the conversation. It now has been documented, and it's going to be harder for me as the opposing appraiser to come back and change my mind on this. So using it not only helps you later down the road, but it helps you in the current appraisal. So after that, now we're going to exchange our estimates. We've come to some agreements and understanding as to the scope of the loss that we're going to agree to. Now we need to exchange our numbers. And there does need to be that exchange of numbers, because just like the aspects of going to the appraisal in the first place, just to actually get there, there also needs to be an exchange of numbers to get it to the umpire. We talked about the language before, where each side needs to determine the amount of loss, and only then, if they can't agree, does it go to the umpire. I have litigated a few claims against opposing appraisers where we had to file suit against them personally because they refused to do things like provide an estimate on the loss. And instead, they took a position of, look, let's just go to umpire. We're never going to agree. I'm not doing an estimate. Let's not waste time. And that position is completely wrong. It is not only, in my opinion, unethical, but it is against the actual policy language itself and should be litigated, because we need to make sure everybody involved, our side and theirs, needs to understand that there are the right ways and wrong ways to do these things. So you've exchanged your positions, you've exchanged your estimates. Now comes the negotiation phase of trying to get it resolved. Maybe it's already negotiated. Maybe by day 40, you're good to go. Everyone's in agreement and everything works out. But if not, you've got days 40 to 60 to have your communications back and forth to try and get these claims resolved. And when they do that, when you have that timeline set in like this, you realize that this entire process for appraisal being done in 60 days is certainly possible. Now, I understand not every claim can be appraised in 60 days. If you've got large commercial fire losses, if you've got complex situations with homes, I have a green home, for example, that is, fully recycling water, its own water usage. It's self-sufficient for its own energy. I mean, it's this incredible property, incredibly unique. Those claims will take more time. I understand that. But this can be a really good guideline to making sure you aren't taking too long on these claims and how to use that. And to do it, you should have these workflows in place to start every time. Workflows can be fantastic and used through software programs like Claim Wizard or Practice Panther, which is the one I'm going to show you in a moment, for automating this system so that you have your reminders that just automatically pop up of, hey, send my appraisal agreement to opposing appraiser today. Send my positions letter to the opposing appraiser today. And it's all automated reminders to do that, and automated letter drafting that really can go a long way to making your life a lot easier through the process. So let's take a look at this because I want to make sure that I do this correctly. And I've never tried this before, so please forgive me if this doesn't work well. Hopefully you can see my screen right now. I can no longer see your comments, but I'm going to pop back over there in a second. So if anyone could just let me know that you can see this, that would be great. I'm going to pop back over. Let's see. No one has written anything. Makes me wonder if you can, in fact, see this or not. Hopefully you can see this, though, and you can see my screen now. This is Practice Panther. This is what we use in my office to manage all of our case files, all of our workflows, contacts, everything that is really done in our office is managed through this software program and is something that is worth looking at. Oh, we can't see it. Okay, so that is good to know. I think I hit the right button now. And now I can actually see you guys too. I see what happened with the program. So can you see it now? I think at least Dave let me know that it wasn't on there, but you should be able to see it now. So this is Practice Panther. Practice Panther, like I said, is a claim management software that is really fantastic, originally designed for attorneys. But I've heard a number of adjusters who use it, and makes a big difference in their process. So taking a look here, I made up a fake client, ABC XYZ is the client, and a fake case, ABC XYZ versus insurance company. And I wanted to show you some of the things that this can do because of how much of a difference it can make in your day-to-day process. So first and foremost, I want to show you a workflow. So on here, all you do is apply a workflow. And let's say that I just got a new case in and I need to do an intake. So I choose my intake workflow, and it automates everything that needs to be done on this file. So, file reviews for an attorney for the statute approaching, a hello phone call from our case manager, follow up on an intake email, draft and send fee agreement. All of this stuff is automated within the system where it creates all of the tasks, you press save, and it's just automatically input into our system. So now that when I go into this file and I press save here, I can see all of the activities, all the things that need to be done on this file right here. And you can even make them conditional, meaning, it doesn't have to be done until something before it is done. It can make a huge difference because you put this in and just say, oh, here's my appraisal workflow, and I can go through that process. But not only that, but it also does forms for us. So you can go into a template and say, I needed to do a letter to the client as a follow-up because they haven't done, X, Y, or Z thing. I can download that. And now all of a sudden I have a letter that is automatically filled in, that it is compliant with all of the information, all of the data that I've put into this can now can now be put into a letter that makes a huge speed difference for everything I've done. So I just clicked the letter, and I want to show you now how easy it is for that to pop up. And this is the letter that is shown. And as you can see, it's automatically put on my letterhead. It includes my file number, the date, whoever the client is with their address, the claim that I'm involved in, their name here, automatic signature. I mean, it's literally a plug and play, everything you could want for a form letter to be done in these claims. It honestly couldn't get easier than that, in my personal opinion. With these losses and with these claims, we should be doing things the same way every time. It makes sure that deadlines aren't missed. It makes sure that things are moved quickly and expedient and efficiently, and really should be used on every single claim. I can't think of any reason not to use it. So if you're not doing something like that, you are going to be doing yourself a disservice. All right, so some keys to good appraisals that I've seen when I go through these. And I should have said this at the beginning, but some people ask, well, Tony, why should we be listening to you about appraisals? I've only done a few appraisals in my career. Truly, I don't get named as an appraiser very often. When I do, I enjoy doing them, but it's really for large loss, complicated, policy language, that type of stuff. But the truth is, I deal with appraisals constantly because I'm getting calls from appraisers and having to litigate claims after appraisal or through appraisal that have issues that come up. So I have gotten to see countless appraisals going through, and can tell which ones are the good ones and which ones are the bad ones pretty early on. And these are some basic things that I see on all of the good ones. Documentation, just like through the claims process, having good documentation through an appraisal is very, very important. So that means putting your conversations in writing. Right? So if you have a verbal conversation, which is perfectly fine, confirm it through writing. Detail your inspections and document those inspections of the loss. I can't tell you how many appraisers I have dealt with that don't document their inspection. And they just believe like, oh, well, I'm going out, I've got to make my opinion. I don't have to support any of this. Or I've got the pictures from the public adjuster or pictures from the carrier. And they just don't document it. Blows my mind. But you should be documenting the loss the same way you would as if you were adjusting the claim. Making sure that there are agreements involved with the appraisal process whenever possible. These are items that can be documented and can make a difference. Long story short, if it can be documented, document it. I don't know. That's the most all-encompassing way to discuss it, but absolutely worth doing. You need to make sure you're moving the appraisal along with purpose. Meaning that if it is stalled, then you are doing everything you can to move it along to the next stage and not just waiting it out to hope for a change of position. That you're going through this process with purpose to not delay these claims and to make sure that you are doing justice to the property owner and the policy as to what should be covered and when it should be covered. So know that timeline and know that ahead of time. If you are in an appraisal on a relatively standard loss for 5, 6 months, 8 months, 10 months, it is taking way too long, and you need to get that thing going. Obviously, we talked about this, but I wanted to say it again. A good appraisal always has a good umpire. You can use the umpire to resolve disputes, right? You don't just have to resolve the umpire to determine the value of the claim. But if you're not getting a response from the carrier, and I think this is going to come up in one of the questions, if you're not getting responses from the carrier's appraiser as part of the loss, go to the umpire, have them reach out. At the very worst, the worst thing that could possibly happen is they still don't respond. And if they do that, now they're not only not responding to you, they're not responding to the umpire. I don't care what anybody says. There is some psychological aspect to making claims determinations. And if you've now had an opposing appraiser who pisses off the umpire, don't you think you're going to probably do a little bit better in that claim? Right? You always want to come across as the reasonable side. Through all aspects of the loss, you want to be the reasonable side. And if you're doing that, you can make sure that you have the most favor on your side for when decisions ultimately need to be made. So really think about that as you're going through the process. Oh, here's where apparently I was going to do the sample form and workflow. I didn't remember my slide order, but it really is easy. If anybody chooses to use Practice Panther and you want to ask me questions, I am so deep. I've dived so deep into Practice Panther. I believe I can answer almost any question. I feel like I could work for the darn company if I had to because of how much I dove into it. So please let me know. There are experts out there in other systems as well. So I'm sure if you just ask around, or heck, ask me if you want to say, "Hey Tony, can you find someone that is really, versed in X program?" I'll find it for you. I don't mind, because that can really make a difference. We should focus as an industry on doing what we can to help everybody. I know that we deal with competitors when we're doing these things, but the truth is it's really an us versus them mentality, not us versus each other. So I'm sure people will be happy to discuss with you ways to make the system better. So common issues that come up in these claims. Now, these are the top 5 things that I see over and over again when I get questions from appraisers dealing with the appraisal process and what is going on. The first one is always umpire selection, right? We can't agree to an umpire. This particular appraiser will never choose someone that's not on their own list. I know those types of appraisers. I know they exist on both sides. And the thing is, they're allowed to do that. I get it. I get that it doesn't feel good. It doesn't feel right that it's my way or no way. But the policy has set provisions as to what to do in those scenarios. And the answer is, if you don't have that selection done within 15 days, go court appointed. If they are only giving you people who you know are not appropriate, go court appointed. And use that information to get the right umpire on the loss. Now, what do I mean by go court appointed? Because this is a personal pet peeve of mine. Because adjusters will contact me and say, or appraisers contact me and say, "Hey, I need you to file a motion to appoint an umpire on a case." Great. And what I'm going to ask for in every single one is I need your list of umpires and why they are good. Give me their resumes, their CVs. Give me some explanation as to why you've got the right people. Give me their list of umpires and why they're bad. Why are you not agreeing to their umpires? Even if it's past experiences. I have worked with McHenry before. I know he's never in his life going to be unbiased. And as a result, I can't possibly agree to him. Fine, tell me that. But give me something as to why they are no good. Third, give me the communication between you and the opposing appraiser trying to select an umpire, where you've explained, "Hey, this is why your people are not good and why I can't agree to them, but here's why my people are okay." If you give me those 3 things, I am far more successful in getting an appropriate umpire appointed than if you just come to me and say, "Hey, Tony, I just need a motion." And that difference is a huge one and one that is worth fighting. Again, having the right umpire on a file is the most important aspect. So if you're going court appointed, you do not want to just go and throw it into the hands of the court and hope that they bring someone good. You need the right argument with the right attorney and the right umpires so that they find someone that can do this the right way. Second, scope agreements pre and during appraisal. So this one comes up, and I touched on it earlier. The carrier is saying they won't go to appraisal because of scope. Before appraisal even starts, we won't go, and as a result, we've got a dispute that can't be resolved. Again, that's going to come down mostly to case law. For example, in Pennsylvania, the insurance company cannot limit the scope of the appraisal at any point. So that in essence, if they've agreed that there is coverage and there's an agreement or a disagreement as to the amount of loss, appraisal is appropriate, and the courts have come back and said that is the end of the debate. Everything is fair game for them to determine the amount of loss. New Jersey, opposite. New Jersey limits the appraisal to the scope that is produced by the insurance company. Until case law comes down that changes that is going to be the guiding factor for New Jersey. So you have to know the state law as to those particular issues. Now, what about during the appraisal process? And I'm going to wind this into number 3, which is communications with the carrier during appraisal. I imagine a number of you have dealt with an appraisal where the opposing side has communicated with the carrier to get guidance on the appraisal. Now, just recently, I had put on the PAGPS conference. I know a number of you were there for that conference. One of the most interesting things that we had was a defense attorney for insurance companies come in and talk for 2 hours with me in front of the crowd to answer questions. An appraisal was a huge, huge issue that came up. And one of the things that he had said, which him and I actually agreed on a lot of things, surprisingly, for as much as him and I litigate against each other. But one of the things I disagreed with is he said that if the appraiser goes to the carrier to ask a question, to ask for clarification on something, and the carrier responds and does something that limits that appraisal when it comes to scope, for example, he said there's nothing wrong with that. He said, however, if the carrier unilaterally reaches out to the appraiser to attempt to limit the scope, that would be inappropriate. Now, I completely disagree with him. Once the claim is in appraisal, the carrier is out. Unless there is something that unless there is a denial on the claim that has come through, there is no question left to be asked because we know what the coverage is. We know that there was a wind claim, a water, a pipe break, a fire. We know what the issue is on the claim. We are only here to determine what is the amount of damage as a result of the fire, the water loss, the wind claim. That's it. Any effect of the carrier changing the course of that appraisal is inappropriate. And they should not be doing it. And you should make sure that that is clear. And one of the things that should be discussed in the appraisal agreement in the very beginning of the claim is that won't happen, that there won't be communications with the parties during the appraisal process because it is meant to be independent. It's meant to be a process outside of the adjustment of the loss. Another issue, we're going to put 4 and 5 together, is your lack of response and your delays. Now, we talked about this, but it's again worth repeating. Use your umpire. Use your umpire to help set your guidelines, set your timelines, and push the claim forward accordingly. You can also, when necessary, if it's really getting bad, contact the insurance departments, although they are much less likely to be helpful through the appraisal process, admittedly, but it probably is worth a letter here and there if it's really getting egregious. You also have the option through any of these problems to potentially pull the claim from appraisal. Now, one of the things that comes up often is that these people ask me, Tony, when can I do that? When am I allowed to pull a claim from appraisal? First, general rule of thumb is if your party was the party that demanded appraisal, you can withdraw the demand for appraisal, right? So you've made the demand, you can withdraw that demand, pull it from the appraisal process, and you're probably going to be okay with that. However, there is nothing that stops the carrier from immediately issuing their own demand after that. They very well could, if you pull it from appraisal, say, okay, you've pulled it. I'm now making a demand for appraisal, and you're going to have to go. It is a requirement under the policy to go to appraisal. So just know that that is one of the options through the process. It can also happen if after it comes to me. I've had some attorneys who demand appraisal on a claim after it's in litigation. I've had them do it after discovery is over on cases. And when we've fought some of those and won, but every once in a while we get a rogue judge that still sends it to appraisal. But there are options to be done when things go south. I'm running a little lower on time. So this I've touched on some of this with my code reds, right? Everything is going bad. What can you do? The other aspect that is important from this slide is if it does go through appraisal and you're not happy with the results, what options are left? And the options that remain really only cover the items that have not been appraised. So generally speaking, you go into a property that has wind and water loss to the roof, to water damage to the interior, and you come through and the appraisers come and they pay for a patch on the roof. Or one slope on the roof. They don't pay for the whole roof. They pay for ceilings and walls inside, but don't pay anything for the floor. Okay, what could go to litigation in that sense? Most likely, the answer is we could go against the floor. And maybe, if you're lucky, you could go for the other slopes, but probably not. Probably what's going to come out is to say, well, look, we did appraise the roof as a whole, and we determined that the amount of the loss as a result of this, to the roof was the one slope. And that's what you get. But they did nothing for the floor. The floor was not appraised. There was no amount given for it, and no aspect of the claim that was addressed in the appraisal as a result. We can still litigate over that. You still need to be cognizant and aware of your suit limitations. So make sure that you are always tracking that. But that's what could ultimately be going to litigation afterwards. If, depending on the scenario, depending on your relationship with the carrier or their adjuster, you may actually be able to go to the carrier directly. If you're not getting responses from the appraisers, and this is one thing that I believe the carrier can step in on, because it has nothing to do with the outcome of the appraisal. It's not giving numbers or scopes or any other aspect. You could go to the carrier and say, hey, look, I've been contacted for the sole purpose of discussing delays in the appraisal, and the opposing appraiser is not getting responses. Here's 5 emails that went unresponded to over the past 2 weeks. Can you contact your appraiser or name someone different and try and get it moving that way? I don't believe there's anything wrong with that, again, because it won't factor into the results of the appraisal. So I think that still keeps it unbiased, and it does something else. It lets them know, hey, the person you're naming isn't one of the good ones, right? They're not moving these claims along. They're causing more problems. And then you might end up getting a position where they don't use them as often or at all after that happens. So, got a good question in from Jason. Can an appraiser provide their client the current agreement of dollar amount and then ask if they want to proceed to the expense and uncertainty of umpire? That's a really good question. And this might have come up, and Jason, I don't know if you asked this when you registered with the questions, but I feel like this might have been in there. It is the appraiser's responsibility to determine the amount of the loss, not the client. And this is a scenario where, can you imagine the reverse of this? Imagine you have an appraiser on the other side who goes to the carrier and says, hey, carrier, do you agree to this amount of money? And if you don't agree to it, do you instead want me to go to an umpire? I nearly guarantee we'd all freak out if that happened, right? It's them, in essence, it's them still making the decision as to the amount of the loss. And it is not for them to make the call. As an appraiser on a loss, you have a responsibility to be doing this as ethically and fairly as you can, based off of your responsibilities and the policy language. And to do that, you can't bring the client into the mix. And it's just one of the aspects of appraisal that is part of that unbiased situation, and that independent aspect that you don't want to be bringing the client into the mix. All right. So as I always plug before we get to the questions, you should really look into joining local organizations to assist the industry as a whole. I'm part of MAPIA. We have unbelievable following now. The PAGPS conference was a huge help. We're up to like 90 some members now, and we're starting to put together the Christmas party, which will have CE credits. But beyond the benefits from an organization like MAPIA, which can be found right here, for only $300 a year, organizations like MAPIA fund lobbyists. Lobbyists are our best defense to insurance companies coming in and trying to pass regulations or legislation that would hurt the industry as a whole. So when legislation is getting presented in the Congress, lobbyists tell us that the carriers are trying to do X, Y, and Z things. With the recent expansion of MAPIA, we are actually starting to get proactive. We are going to be going to present some bills ourselves for approval to try and get some regulations to assist homeowners in situations of loss, so that carriers don't take as much advantage of them. I cannot stress how important, invaluable these organizations are to the industry as a whole, and I would highly suggest doing those and joining one of those. MAPIA is just one of the great options. There's a number of other organizations as well. So let's talk about some of the questions. Can an insurance company not provide for an umpire in their appraisal provision? And there was another question, is an appraisal clause without an umpire legal? This is a fantastic question, and it will come down to state specifics. So a number of states have a certain base requirement for what an insurance policy offers. And depending on what that state based off of, if it's the standard New York policy that was issued, 100 and some years ago, if there are minimum requirements, then it would be illegal. It would be a breach of the agreements to have a provision without an umpire, because having the umpire as an option is one of the minimum requirements within the policy. However, if the If the policy is, for example, a surplus lines carrier, if the policy is in a state that doesn't have minimum requirements and only needs approval from the department, then there is no requirement to have an umpire as part of the process. Now, I've never actually seen this, so I would be very interested to see a policy without an umpire provision, because I don't know how that gets resolved in the end. It makes obvious sense to have the umpire involved, but I would be very curious to see those provisions and if they're really prevalent in the industry. Here's a really important one. Ed asked it before, and I want to talk about it because it does come up. How do I object to and get a known biased or incompetent opposing appraiser discharged from handling the claim? Now, first and foremost, understanding what it takes to truly become biased or incompetent is probably more than what you're thinking. It's not enough, like I said, to just do 40 claims. Ed gave the great example of someone who derives 25% of their income from a particular carrier as evidence of bias. I think that's great evidence of bias if you've got it. But if you've got somebody who does appraisal work for 25 different carriers, and on top of appraisals, they also do IA work, and they deal with things differently, then you're not necessarily going to be able to rise to the level of bias. So the first thing you're going to want to do, though, if you think you have this, if you think you have a situation where there is an issue of bias or incompetency, you're going to want to send a letter to the carrier explaining why you're objecting to them. And it needs to outline very clearly with evidence why this person is biased or incompetent. It is not going to be good enough to you never want to just send it to me or an attorney first. You want to show evidence that you have in fact tried to get them to change their position without legal intervention. So send them a letter giving the evidence. Say, look, I've dealt with this appraiser on 16 different claims at this point. The last claim we had, they disclosed to me that they do all of their work for Farmers Mutual, and as a result, they're clearly biased. Or they're incompetent because they disclosed to me that they don't know how to estimate a loss, and they've used third parties to do all of their estimating when on a claim, and that doesn't meet the criteria for competency. Now let's assume the carrier says, "Too bad, so sad. We're not doing anything further." Then you're going to want to contact an attorney, and the attorney can file a motion with the court to have them removed from the claim. It does not have to be full-on litigation or a lawsuit. They can do motion practice to get them removed from the appraisal if it's really worth it. Now, a lot of times with these claims, I get questions from appraisers on claims where there's a dispute of $5,000. Look, if you want to get me involved to file a motion for a claim that's only worth $5,000, that's fine, but it's probably not going to be worth it in the end if it's only that kind of dispute. So make sure you're kind of making that calculation involved. If once the attorney gets it, they can, like I said, file the motion and hopefully have them removed. Truthfully, one of the options that may or may not happen, depending on what your desires are, is we will reach out to the carrier directly and say, "Hey, look, can we come to some other agreement on this, either to settle the case or to just name new appraisers, or have a new appraiser named, see if we can get to that agreement without motion practice." But those are really going to be the options that you've got. The real key to all of this is the proof, right? It's not good enough to just say things. You have to have evidence. So if you're going to try and build a claim against incompetency or bias, you should be documenting, "Hey, I've worked with, John Smith on this many claims and this many things have happened, and now I've got my evidence." Make sure you're documenting that if you're going to try and fight these things. All right, this one got cut off a little bit, but I think I can probably make it work. What do you do to prevent the following situation? You go to an appraiser and you go to appraisal, and the other appraiser and the umpire agreed to an award, but you don't. And then the clients can't find a contractor to do the work for the price of the appraisal. The data you were bringing to the appraisal is a contractor's contract with the insured and other supporting subcontractor bids. That's a great question, and there is not a good answer, and not one you're going to like. Most likely you're out of luck. Most likely you've got a binding appraisal award, and the appraisers are going to be in a situation that there's not really any options for them to do. If you've got a scenario where the appraisal didn't include items like we talked about before, if they didn't appraise the floor, if they didn't appraise the bathroom, if they didn't do those items, there may be options for litigation after the appraisal in that scenario. But if everyone's agreed on the scope and it's just you don't like the number, I am sorry, there's not really much you're going to do unless you could, of course, show some level of fraud or misconduct or something similar to that. When I just want to pull this question up so I can read it while we're here. When we are in the starting phases of the appraisal, what standing do we have to ask the opposing appraiser questions? Mr. Appraiser, what percentage of your work comes from XYZ carrier? This is something that Ed brought up before, and I see Ed actually just responded to this. Again, you are free to ask the questions. You can ask any question you want. They don't have to necessarily respond. So you should have a questionnaire as to every appraisal that's going out as to the common questions that you're going to be going over. If they don't respond, not much you can do about it, but it's at least worth asking about. The lack of response can absolutely be something I would use later in the litigation, as Ed has suggested in his answer, to show that there's some other issue with these appraisers that the carrier is not willing to disclose. All right. How do you negotiate for a preferred umpire? Fantastic question. I know I'm going over my hour a little bit, but I think these questions are really important to the process. The choice of the umpire is so critical. You absolutely should be going into it with a good negotiation tactic. And it is a negotiation. So I appreciate how the question was worded, because it is that kind of negotiation. One of the things that I have used when I've gotten involved in the appraisal process is making an effort to make decisions on an umpire without choosing a name yet. So, for example, talking to the opposing appraiser and say, hey, look, there's a few aspects of this claim that are unique, right? There's some unique construction involved, or there's some other unique aspects of coverage that need to be addressed. So we need someone specialized in this. Before we start choosing names, can we both agree, I really think we need the umpire on this case to be a contractor, or the umpire on this case needs to be an engineer, or hey, this is a really unique aspect of appraisal. Should we have someone from the IAUA act as the umpire on this? Get to agreements that don't actually name the name before you ever do that. You can also use it. Hey, would you agree to use someone, that isn't one of our regular players, right? Someone that you haven't used 60 times before. So, and I'll do the same, right? This is not a one-way street. I'm going to do the same thing. Try and find somebody who I do feel is unique to this claim and the specifics, and try and do it that way. It's a great way to limit your world of choices before anything goes any further. Again, the hardest part of it is choosing the name. So get everything else you can agree to, and then your list of names is much, much shorter. Number two, when you provide your list, which inevitably will happen, first and foremost, I would let them provide a list first. See if maybe there is someone on there you're okay with, right? I think it's probably rare, but maybe there is someone you're comfortable with on their list. So let them provide their list first. Assuming that you are, you're going to provide your list second, give them the reasons you are not saying yes to them, because you need to have some reasons. The benefit, by the way, of you sending yours first is you haven't already said no to them. If you do send your list first, the one big benefit, is, again, you haven't said no, so they're not in this kind of defensive position. So it really could go either way now that I'm thinking this out as I talk it out. Other than that, you really need to get into the bases for the position you're going to take, right? So many people say no just to say no. But if you can back it up, if you can support your basis for saying no, hey, I can't use this person as the opposing umpire because they're a restoration company on the preferred list for the carrier, and I know they derive a high percentage of their work from that carrier, and it clearly would not be unbiased, right? Just some short explanation can go a long way to them not fighting over it. It also opens the door for them to give an explanation as to why why they won't say yes to yours. And that's the other thing you should do. If they say no to your entire list, ask for a basis. There are a number of appraisers I know out there who are bullheaded, strong-willed, however you want to put it, on both sides, candidly. But for carriers that will just refuse to tell you why. You never want to be the person who refuses to explain why you're doing something. And if you can't explain why you're doing something, maybe you should be rethinking what you're doing. So if you put them in a position where they have to ask the question or answer the question, why am I saying no to these people, and they can't do it, you've now got a leg up in the event that you need to contact me or someone else to do this work. Now, for me, my office charges $1,500 flat rate to write the motion and argue the umpire motion in court. And candidly, I think we end up losing money on it, but it's something that we're happy to do because we do believe it is a good way to resolve claims. Not every claim is good for appraisal, so they're just not. But a lot of them are. And if you can use appraisal on the right claims to the right benefit, then we're always happy to help. So this goes to the question we talked about before of whether or not you should seek client approval before signing an award. Unquestionably, no. In my eyes, that should not be part of your process. If someone feels strongly the other way, anyone that's on here that does a lot of appraisals, I'd be happy to hear why you think otherwise. But from my position, it's a resounding no. What do you do when the opposing will not reply? Will not reply to requests to discuss your differences of your appraisals. First and foremost, use the umpire. That's always going to be your best first stop to try and get these claims resolved. And if that still doesn't work, you're going to have little choice but then to ultimately go to the umpire anyway. We've talked about some of the other options for resolution, contacting the insurance department, but really it's going to be an umpire dispute at that point. All right, my dog is snoring over here. I don't know if you can hear that. It's wild. Piper. Yeah, crazy. One flaw of being home, or benefit, I should say, but flaw of being at home with the snoring dog while they sleep. All right, how much should you not communicate with the appraisal client during the process? You should not be contacting the appraisal through the appraisal process. I can't think of many reasons you would ever need to contact the client through the appraisal process. There may be some extenuating circumstances. You've been provided a contractor's invoice or an estimate for the claim, and you need to get the contact information for the contractor to discuss something. There's probably some nuances in there that could fit as the exception, not the rule. But you should not otherwise be contacting the appraisal client, just like you wouldn't want the carrier talking to their appraiser or the umpire. You don't want to be talking to the client either. When should I use, this has nothing to do with appraisal, but I wanted to answer it because I always tell everyone I will answer a question if they ask it. When should I use an industrial hygienist on a water claim? Short answer is when you need them to prove something the carrier won't otherwise agree to. So if you need to bring them in to prove the extent of damages or the mold remediation or smoke damage to a property because the carrier is not agreeing, that's when you want to bring in the hygienist. In essence, use it to support your position that the carrier will not otherwise agree to. All right, ladies and gentlemen, that is everything for appraisals. Went a little longer than usual, but this is such an incredibly hot topic in the industry right now it just keeps shifting and changing. I mean, what appraisal has done over the past 10 years, no one could have guessed this. So we're really doing what we can. So as for states we work in, actually one of my attorneys is licensed in Illinois. He's actually from Chicago originally. But to do an appraisal out there just to appoint an umpire probably can't justify that for the cost since he's out here. But other issues in Illinois, we are happy to help with. Right now, we have either licensed attorneys or of counsel in New York, New Jersey, Pennsylvania, Maryland, Virginia, North Carolina, South Carolina, Florida. So, and Illinois. I always forget Illinois just because he doesn't go out there much. But we're happy to help. We're expanding into Ohio shortly, which we're pretty excited about. And we're going to continue to expand because we do feel that this industry needs the right people to fight the right fights on these claims so that we get to the right decisions. As always, thank you all so much for these. If you have any other questions down the road, please. Sorry, I just read Dave's comment. which I'll be happy to pop up here just because it did make me laugh out loud. But if you guys have any other questions, please contact me anytime. I am always happy to help. My cell phone number again is right there. My email address. Anything you guys need, I am happy to help. Doesn't cost you a penny to give me a call, or shoot me an email. So whatever I can do, please let me know. Thank you all so much. And I look forward to seeing you next time. Take care.